Okay, that was a lot.
That is a lot.
You lawyer guys.
I gave you a congressional filibuster. You have to appreciate that Kalshi has figured out a game plan for keeping the states at bay and taking advantage of an administration that's basically adopting a hands-off approach. This would have happened in no other presidential administration.
The Business of Betting podcast is presented by Optimove, the #1 CRM marketing solution for the iGaming industry. 4 out of the top 5 U.S. operators personalize player experiences with Optimove, the #1 CRM marketing solution for the iGaming industry. Learn more about Optimove by requesting a demo at optimove.com/businessofbetting. And if you like what you see, you will get your first month free.
What is up, everybody? I'm Jason Trost, host of the Business of Betting podcast. I'm joined with Dan Wallach, sports lawyer extraordinaire. I'm very happy to have Dan on the podcast. We've actually never met or spoken in person, but I see his name everywhere. He's up to speed on all the latest of what's going on in the industry. And I've just discovered he's a huge Springsteen, New Jersey, New York Sopranos fan. So welcome to the podcast, Dan.
Thank you very much. And you could throw in Southside Johnny and the Asbury Jukes and the New Jersey Pizza and the New York Football Giants. So I'm a native of Queens, grew up in Long Island, but my heart is in New Jersey. And I think that's kind of my claim to fame, a little bit how I sort of ascended in this space. I was following the New Jersey march to get legalized sports betting, and I was blogging and writing about this over 10 years ago. So New Jersey is very, close to my heart. Anyway, thank you for having me on. It's been a long time for me to make my debut on the Business of Betting podcast. My buddy Jake Williams started this whole thing, and I never once got an invite. So I really appreciate finally making the cut.
Maybe it ended up in spam, the invite. You never know. So you're a lawyer by trade. What did you do before you got into the sports betting malarkey?
I was an appellate lawyer for so many years. I was a litigator on the sort of the trial level, federal court, state courts, and then I became more of a concentrating in the law surrounding appellate courts, where you take cases up on appeal to state and federal appeals court. I was always a very good writer, and I was in cruise control for so much of my career. I mean, you're somebody who, right out of the gate, went to a great school, had a sort of a direction as to where you wanted to go in life. I wanted to be a lawyer, but I wasn't sure where I kind of fit. And it took about 15 or 20 years before I even made any inroads or even thought about the gaming industry or the sports industry. I was a frustrated sports writer. I was a sports obsessed person in high school, college. I did a lot of writing for my school newspaper, but I put that all to the side and I pursued a conventional career in accounting, commercial litigation. And then along comes the New Jersey efforts to legalize sports betting, and everything catalyzed at that one moment. At the same time, my firm pushed some case to me that was dormant. Nobody wanted to handle it, and it involved gaming, and in particular, a dispute between two licensed horse race tracks that were arguing over who has the entitlement to get a simulcast signal. Anyway, something about that case just sort of enlivened my gaming nerve. And I said, this is such a great area. I'm going to start a podcast. No, I'm going to start a blog and begin writing about stuff. And the first topic that I wrote about, the one I obsessed over, was when New Jersey was battling it out with the NFL, NBA, Major League Baseball, and the NCAA in the federal courts over New Jersey's fight to legalize sports betting. And that created sort of everything that followed. It was all serendipitous in my early to mid 50s, which is a very rare opportunity and kind of late in life to do a career pivot. But if I could do it, I think it should be inspiration for anybody.
That's a really nice story, because I think a lot of lawyers, you probably know better than I do, but from the outside, lawyers seem very conservative in life choice, not conservative necessarily in political leanings, conservative about stepping out of the firm to do left field things. So that must have been quite a big jump for you.
Or you have a midlife crisis and you begin questioning everything.
You didn't get a motorcycle?
I'm scared of motorcycles. I remember I rode one time in my life on the back of an ex-girlfriend's motorcycle. One time was enough in life, but it was pretty fun. me to the beach, and it was in Fort Lauderdale. It was so much fun. Anyway, that's a podcast for another day. We'll make that a two-parter. But for me, it was, well, I don't think I had any other path interested me as much. I mean, I think in my conventional career as an attorney, I didn't really have my own clients. I was handling appeals for some of the existing firm clients. I was really good at it, make no mistake. I mean, I could have gone into cruise control for the rest of my career, made a nice, living, six-figure type living, being a non-equity partner at a law firm, handling appeals that nobody outside the firm gives a shit about. So I think I was struggling with trying to find something that tapped into, my ambitions, my interests, something that I love, that I would wake up every day and not think of it as work. And this became it. And it wasn't even a career plan or business plan. It just kind of fell in my lap. Like there was somebody, looking out for me, somebody watching over me to say, here's your opportunity, run with it. And when you're in your mid-50s, as I was, you don't get too many more of those opportunities if you don't grab them at that time. And I realized I was into something big because this was about to start a revolution. At the time, I didn't realize how quickly it would accelerate, but I was like the Neil Armstrong, on the issue of legalized sports betting. There were two other attorneys who were also doing it too, Griffin Finan, who eventually went to work for DraftKings, and Chris Soriano, who's now the head of legal compliance for Penn Entertainment. So there were some other folks, but I worked it the hardest. And it didn't matter what happened in the New Jersey litigation, I would write about it. I would send it out to people. I would heavily promote myself, and there I became reborn as an attorney in roughly mid-2014.
Just a quick side legal bar. I'm interested in politics. I follow it way too closely. This in appellate courts, it seems like Trump always wants to jump to the Supreme Court. What is the mechanism where you can skip all the tiers? First of all, how many tiers are there? And how does Trump get to skip tiers sometime and go straight to the top?
Please. You went to a better school than I did. You went to Northwestern. I went to Hofstra. You should know the answer to that. Okay, we have two parallel court systems in the United States, so the state courts and the federal courts. You're focusing on, sort of federal law, federal statutes. There is the federal district court where all the Kalshi lawsuits are now playing out. And then there's the intermediate appellate courts, which are the circuits, First Circuit, Second Circuit, Third Circuit. There are 13 circuit courts. The New Jersey sports betting lawsuit with the NBA and Major League Baseball and the NBA, that played out in the Third Circuit in Philadelphia. And then there's a further right of review. It's not even called an appeal. There's discretionary review by the country's highest court, the U.S. Supreme Court, and they handle matters either directly from the intermediate courts of appeal at their discretion, or in some cases, there could be some original subject matter jurisdiction where you can go directly to the Supreme Court. The Supreme Court, generally takes a lot of these presidential type cases over the scope of executive power. So it's really a long shot, the longest of long shots to get your case accepted by the U.S. Supreme Court. I think the average rate of acceptance is like between 1% to 2% out of thousands of petitions filed every year. But when the petitioner is Donald J. Trump Jr., the president of the United States, and you're represented by some of the top law firms in the country, I think the percentage rate goes up to way north of 50%.
It feels like Trump, at least with some of his other shenanigans with the documents case and the throwing the election, the insurrection stuff, like he threw sand in the gears and he could just roll it out, especially for this trade dispute, like time's of the essence. So this, like, it's in his interest for it to not rocket ship to the Supreme Court, for it to drip along. So while the stay is in place, he can keep doing his stupid negotiation.
I suppose, but it's still a long, time frame between stay and final decision, or between lower court ruling and final decision. He's got so many balls in the air here because he's so in chaos all over the country. These are very unusual times. These are very dangerous times. And incredibly, this even intersects with one of the issues we're going to talk about today, which is prediction markets, none of which would be possible unless Donald J. Trump were president of the United States and his son is a strategic advisor for Kalshi. All of it.
World-renowned expert in prediction markets, no less.
I don't know if this is the next great scandal, but if you're looking at potential for conflicts of interest and actual conflicts of interest and self-dealing, I mean, I hold out sports prediction markets as Exhibit A. By the way, I love the product. I want to see the product made legal. I think it's innovative. It's fair for the consumer. You eliminate some of the geofencing issues from state to state. I think it's inevitable that prediction markets and around sporting events and other kinds of events are ultimately going to become legal, but I question the process by which it is occurring, not the legitimacy of the product itself, but the legal shenanigans that are going on in the background.
Well, I definitely agree with that. Why don't we jump into that? Because when I assume you're at SBC Fort Lauderdale. I mean, that's all anybody can talk about in the industry.
I was on a panel with Chris Gerlacher, who's the editor-in-chief of Prediction News, and we had a riveting panel discussion. It was crossfire with me, Alex Kane, and then Melissa Blau, Dave Aaron from Jones Day, who's a CFTC guru, one of the smartest people I've ever met. So we stole the show at SBC, and it really is indicative of how hot this topic has become, because that's all anybody wanted to talk about.
So let's get into it. What's your take? What's your hot take?
My hot take is I don't see the congressional authorization for this, right? I mean, if the linchpin for legality from Kalshi's perspective is that in 2010, when Congress passed the Dodd-Frank Act, which created this special rule that allowed the Commodities Future Trading Commission to prohibit certain kinds of contracts as contrary to the public interest, and gave the CFT jurisdiction over swap contracts, that nowhere in that discussion was there any green light for sports wagering. I believe what the CFTC is about to do here, if they do anything, would constitute a rewriting of the Commodity Exchange Act. There's no specific authorization for sports wagering, and plenty of counter evidence that suggests strongly that Congress did not want to see sports gambling conducted on the derivatives markets. I think today, if Congress could look at the situation anew in the light of expanded legal sports betting, it might favor that. But in 2010, which is the measuring stick, which is the time frame to evaluate for what congressional intent was and whether the CFTC had the authority or the jurisdiction to allow this kind of event contract, I think all signs point against it. And that's where I come out legally on it, even though I love the product, even though ultimately I see this as part of the future of sporting events, and just prediction markets generally. There is a place for prediction markets for many reasons, but I think it's Congress's role to decide that, not a federal agency's role.
Not to be too funny about it, but there's a lot of things Congress has a role for that they're not really doing anymore. So
I know, but that's our separation of powers. Congress passes laws.
They're also responsible for the tariff policy, but that's not really going on right now. Let's say you're correct with your legal interpretation, and I think I would largely agree with what you just said. What's the so what?
The so what is you have 38 states that have created a licensing process and a regulatory framework to protect consumers, to protect sport integrity. You have dozens, hundreds of companies involved in this ecosystem that have spent significant monies to pursue licenses, to create products that are operated under a state regulatory framework, and it generates a significant amount of tax revenue for these states. And most importantly, it provides a whole number or series of robust consumer protections around responsible gambling, KYC, sports integrity. All these regulatory safeguards are designed to protect consumers and to protect the integrity of sporting events. They were carefully thought out. They were by design. States have to approve bets. They approve who becomes licensed. They approve certain kind of bets. Whereas in the CFTC side of things, there is really a paucity, an absence of any kind of sports-related integrity framework. There aren't anywhere near the same kind of consumer protections around RG, and the companies, especially Kalshi, are basically operating without permission. They've been set up initially as a designated contract market, which is a very time-consuming process that they've cleared, which is almost akin to being licensed. But once they are designated as a DCM, they can self-certify any type of event contract they want and hit the ground running and begin offering it and listing it for trading the very next day. And that's a little bit of a dangerous kind of laissez-faire approach that the CFTC is taking, because let's face it, the CFTC is not doing anything to rein in Kalshi. And this is all by design, that there hasn't been even a roundtable that was promised. The CFTC was going to hold a sports prediction markets roundtable on March 30th, never occurred. There doesn't seem to be any expectation that there will be rulemaking to formally approve sports prediction markets and prediction markets in general. So what is occurring right now in a vacuum is non-enforcement of the CFTC's own regulations. And the current regulation, and in particular, CFTC Rule 40.11A1, is a categorical blanket prohibition on all event contracts which reference, relate to, or involve gaming, war, terrorism, assassinations, and illegal activity under either state or federal law. So the CFTC, under its existing regulations, they have a duty to force Kalshi to remove those contracts. And instead of doing that, the CFTC has adopted a hands-off approach and is not even enforcing its own regulation, isn't even trying to change the regulation. But the regulation that's on the books right now is an express prohibition of gaming contracts as being contrary to the public interest. Now, you might question whether that prohibition and that rule is antiquated in light of some of the more recent post-PASPA developments, which have led to 38 states legalizing sports betting, but it's incumbent on the CFTC to change the rule, withdraw the rule. That's a lengthy process that's governed by the Administrative Procedure Act, but they haven't even done that. So there's an existing ban on the place, an existing ban on gaming event contracts. The sports contracts that Kalshi offer are by their own admission, gaming contracts, and there's no enforcement authority. It's almost like the Wild West. They can do whatever they want. And it appears to be by design because the president's son is a member of the Kalshi team, is a strategic advisor, probably holds stock. And the status quo, which is really Kalshi operating almost like a monopoly. There may be one or two other companies. There's Robinhood, there's Crypto.com Group. I think Sport Trade wants to become a designated contract market. But for all intents and purposes, Kalshi has the space almost entirely to itself in the face of a CFTC regulation which forbids that activity, and in the face of the Federal Wire Act, which expressly prohibits businesses engaged in the business of betting or wagering from accepting bets or wagers across state lines. And what are the event contracts that Kalshi is offering? By their own statements, they call it legal sports betting in all 50 states. Throughout their social media promotions, they've continuously and consistently referred to their event contracts as betting, wagering, and gambling. If that's not a violation of the Wire Act, if that's not a violation of Rule 40.11A1, it's only because the agencies responsible for enforcing those statutes and rules are allowing that to go on knowingly and in plain view because they don't want to put a stop to it. And it's really left to the federal courts it's really been delegated to the state governments to try to enforce these rules and statutes. And so far, Kalshi has been very successful at keeping states from enforcing their state laws and regulations against Kalshi.
Okay, that was a lot.
That is a lot.
You lawyer guys.
I gave you a congressional filibuster. You have to appreciate that Kalshi has figured out a game plan for keeping the states at bay and taking advantage of an administration that's basically adopting a hands-off approach. This would have happened in no other presidential administration.
If I were to summarize your filibuster, you would say that Dodd-Frank prohibits this, the CFTC regulations prohibit this, and the Wire Act prohibits this.
With one correction, Dodd-Frank grants the CFTC the discretion to either approve or reject event contracts involving gaming.
But you're saying the legislative history in Dodd-Frank implies that they would not be copacetic with sports betting via the CFTC.
Yeah, there are several exchanges between Senator Lincoln and Senator Feinstein in which they have that colloquy over not using derivatives markets for gambling, for traditional gambling.
Legislative history of Dodd-Frank, Wire Act, and the rule book of the CFTC. Those are your three arguments. In terms of the Wire Act, my understanding is it's almost never enforced anymore. It's kind of a dead law in a lot of cases. So I might strike that off from being a dead law. I get the legislative history, but that kind of falls under it's a gray bucket, right? And then the third thing with the CFTC, I'm just pushing back in your arguments to see what you say about it. But the Dodd-Frank legislative history is in the gray bucket. Wire Act is not enforced anymore. And the rule book is like, who gives a shit about the rule book if the people who are running the agency don't want to use that rule anymore?
That's a great point. The way it comes into play here isn't through enforcement by the federal government prosecuting anybody. We know that's not going to happen. Where it comes into play is in this litigation surrounding the preemption issue.
State versus federal.
State, Kalshi versus state. Kalshi is arguing that federal law preempts state law. And
why aren't they right on that? Because you think because they don't legally have the right to do this, they don't have a preemption right. Is that your argument?
No, my argument is multiple pieces. Like Kalshi's primary claim when they go into the court, what they allege in their complaint is that their contracts are lawful under federal law. And that allegation is central to even having standing to sue. It's central to their claim of irreparable harm, which is the reason why they would be seeking injunctive relief, because they'll be irreparably harmed if the states turn around and begin prosecuting them. So the Wire Act and the CFTC regulation that bars event contracts, that, in my view, nullifies or at least pushes back against the central allegation that these contracts are lawful under federal law. So if you disprove that, if the contracts are not lawful under federal law, then Kalshi has no standing to sue, cannot possibly claim irreparable harm. And it also ties into the preemption issue, because the thrust of Kalshi's preemption issue is that when Congress passed Dodd-Frank in 2010, that basically divested the grant of exclusive jurisdiction afforded to the CFTC over swaps, divested state governments from regulating or going after the activity as it occurs on CFTC exchanges, even if it is sports betting. And I would say that Dodd-Frank did not create this federal preemptive effect, because at the time Dodd-Frank was enacted, you had the Wire Act on the books, you had PASPA on the books. So you use the Wire Act, PASPA, and even IGRA, the Indian Gaming Regulatory Act, as evidence of congressional intent in 2010. And it's a sort of a counterweight to Kalshi's argument that Congress had intended for sports event contracts to be under the exclusive purview of the CFTC when Congress passed Dodd-Frank in 2010. So that's where the Wire Act and the CFTC regulation banning event contracts comes into play on the preemption issue. But taking it further down the road, there's also another aspect to these Kalshi versus state lawsuits where these two statutes and rules come into play. Kalshi is asking for a preliminary injunction. And you have to prove four things to get a preliminary injunction, one of which is that it would serve the public interest to grant Kalshi a preliminary injunction. They have to show that they're likely to succeed on the merits. That's the preemption issue. That they're going to be irreparably harmed, that it would serve the public interest to have an injunction, and that the balancing of the equities favors Kalshi. It's a balancing test. And where the CFTC inaction on this regulation comes into play is that it's against the public interest when a federal agency fails to follow the law. Now, while the CFTC is not a party to the Kalshi versus Maryland or Nevada or New Jersey cases, what I'm arguing is that this CFTC regulation 40.11A1 is so clear-cut, so unambiguous, so plain on its face that it constitutes a blanket prohibition against event contracts tied to sporting events, that the CFTC's inaction on that is akin to failing to follow the law. And when a federal agency fails to follow the law, there's a whole line of case law which states that that is against the public interest and is grounds for denying a motion for preliminary injunction. So that's where the CFTC regulation comes into play on the lawsuit side. It undercuts Kalshi's standing, their claim of irreparable harm, and it nullifies the public interest prong of a preliminary injunction analysis. So while there may not be a quote unquote enforcing authority, there is a judge who will evaluate the issue of preemption and evaluate whether Kalshi has successfully demonstrated each of the four elements of a preliminary injunction. And the court will necessarily have to do an analysis that takes into account the Wire Act, Rule 40.11A1, and the effect of the CFTC's non-enforcement of that regulation. And then even going further, there's the issue of Kalshi's prior statements in the DC District Court case and the DC Circuit case arising out of its challenge to the CFTC's rejection of its political event contracts. And in that lawsuit, Kalshi made a number of statements that suggested that sports betting was not something that Congress wanted to be conducted on the derivative markets. And all those statements go to the issue of irreparable harm. And then Kalshi, when it self-certified its event contracts for sporting events, they made a representation on that document that it filed with the CFTC that it was in compliance, that these event contracts were in compliance with CFTC regulations. And if there's a CFTC regulation on the books which says that these contracts are prohibited under the CFTC rule, then how could Kalshi self-certify that they're in compliance? And since I maintain that that's a false certification, that also ties into the issue of the public interest, the balancing of the harms, unclean hands, irreparable harm. So while there isn't necessarily going to be an enforcement by the U.S. Attorney's Office or by the CFTC, these are legal considerations that a federal judge will take into account in deciding whether Kalshi's preemption argument is meritorious and whether it is entitled to the extraordinary remedy of a preliminary injunction. So it all ties together with that.
The preliminary injunction being stopping the states from suing them over and over again. Right. Okay. So I think I followed the thread of all of that. I guess my read on it is that a federal judge, obviously I'm in your world, not mine, but a federal judge will say, this is the purview of the federal government. The federal government regulates itself. It has its own agency. It's up to that agency to decide if it's kosher or not. The CFTC's obviously decided this is kosher, therefore they're following the rules, therefore preemption kicks in.
That's their argument, and they've been successful.
It sounds like a winning argument to me.
Not to me, not to Maryland, not to the Nevada Resort Association, and maybe not even to Judge Adam Abelson in the District of Maryland, because he was concerned by some of Kalshi's prior inconsistent statements that were made in the election control case. So the winning streak is potentially in jeopardy in Maryland, but I'll agree with you. That's the argument Kalshi's making. I'll agree that that's the argument that the federal courts so far have credited, but I don't think it's the correct result or the just result, and the book isn't closed on that. And until the appellate courts have fleshed out this issue with the benefit of amicus curiae briefs from outside stakeholders who are adversely affected, like casinos and tribes, I think too much credence is being played in the first judge's decision, and I think that might have been a byproduct of not the greatest legal arguments made by the Nevada Attorney General's office. And one of the tactical mistakes the states have made so far is they haven't hired outside counsel to litigate these cases against Kalshi. Kalshi is lawyered to the hilt. They had Jones Day represented in D.C. and Milbank Tweed, or now Milbank, representing Kalshi in these federal lawsuits. This high-powered law firm, some of the smartest lawyers in the country. And I'm not saying that the state attorney general's offices aren't smart lawyers themselves, but their concentration and focus as part of their job is mainly state law. And it might have been more beneficial had Nevada, New Jersey reached out and retained counsel of the same ilk, because Milbank has had the benefit of almost months of preparation to polish up their arguments. And when they move for a preliminary injunction, the states are right away on their heels. They got 2 weeks to respond, and they're not using outside counsel. And I think it's beginning to show in some of the results. Now, by contrast, when New Jersey fought the battle in Christie 1 and Christie 2 over the legality or constitutionality of PASPA, the state attorney general was part of the team, but Governor Chris Christie reached out to Ted Olson. Ted Olson is one of the most legendary appellate lawyers in the country, one of the most influential lawyers in American history. They paid him $2,000 an hour. And I would submit that that was probably the best return on investment in the history of New Jersey. And I think some of these battles may have been lost with the choices of counsel or the non-retention of outside counsel. And I think that will begin to change as the case goes up to the courts of appeal and outside parties such as the Native American tribes, the commercial casino groups begin retaining outside counsel to argue these cases and argue federal law more persuasively, more convincingly. I read Nevada's brief. They had a very threadbare federal argument. I mean, I knew that they were in trouble once I read that brief. And Maryland, each time a state gets a chance, they have the benefit of learning from some of the prior rulings and some of the prior mistakes. But I mean, you got to, if this entails hundreds of millions of dollars of lost revenue over a long time horizon, why wouldn't you spend top flight outside counsel to work hand in hand with your state attorney general's office rather than to place the onus entirely on, one senior deputy attorney general? I mean, it's a matter of, you got to bring your artillery, your heavy artillery to bear in the fight for your lives, the fight for your economic lives.
Going back to one of my original questions when we started, like, how does this play out in the appellate process? Is this like a 10-year thing, 5-year thing, 1-year thing? Like, when are we going to find out what a federal judge thinks about this?
Well, there are going to be two types of lawsuits. There are the lawsuits now federal lawsuits to keep states at bay. But then later on, when the CFTC formalizes prediction markets and enacts a rule expressly allowing event contracts around sporting events, that rule will down the road be challenged in federal court under the Administrative Procedure Act as an overreach by the Commodity Future Trading Commission. But that's a long way away. We're not at that stage yet. Right now, we're in the stage where states are trying to enforce their state laws against Kalshi. Right now, there are only 3 lawsuits, but there are 6 or 7 cease and desist letters. So we could potentially see more lawsuits. And I think if you're looking for a time horizon, I think with the appellate process taking into account, you're looking at probably much of next year before this final resolution. And then there's also the possibility that this could go up to the United States Supreme Court. So it could be a 2 to 4 year window before this issue is completely resolved. Now, on the trial court level, we're already saying New Jersey's preliminary injunction granted to Kalshi. Nevada has granted a PI to Kalshi. So the district court cases are proceeding on a faster track because they're being decided early on a motion for preliminary injunction. And the balance of the case, it will either be consistent with that, with some little bit of discovery, and then go up to the courts of appeal. Right now, we have one appeal, which is before the Third Circuit. New Jersey immediately appealed the preliminary injunction granted to Kalshi. And I imagine whoever loses the PI in Maryland will take an appeal to the Fourth Circuit. So you're going to have parallel tracks with cases proceeding at the district court, Kalshi versus state A, B, or C. And then there'll be appeals of some of those decisions where the loser takes an appeal, and you're going to be seeing parallel legal proceedings, district court, federal courts of appeal. And that could be a 2-year process before it is completed. And then things pause for a while. And if the CFTC enacts a formal rule, then there'll be a second tier of litigation challenging that rule. So I think the issue is ultimately going to be decided by the courts. Either right now, if some judge or some appellate court steps up and says that these event contracts are clearly gambling in disguise, they're barred by the Wire Act, states can do whatever they want to enforce it. So it's possible that we'll have a resolution as part of this tier of litigation. But even if Kalshi prevails and there's rulemaking, the rulemaking itself will spawn another set of legal challenges. So I think we could have a very busy docket in the federal courts over prediction markets for the next 3 to 4 years that will occupy the balance of the Trump administration. And then when there's a new president, then everything will get reevaluated. But I think in the short term, it certainly appears that prediction markets around sporting events are going to remain in place for most, if not all, of the remainder of the Trump administration, unless a court decides differently. And no court has ruled against Kalshi as of yet.
Well, as somebody that's been doing prediction markets for 15 years, I did not have this on my bingo card. So I'm pretty...
Why aren't you doing it?
We are. We're starting that DCM process. And
how long does it take? How long does it take to...
1 to 2 years.
Is that because the CFTC is understaffed, or that's typical?
No, they're supposed to respond within 180 days, but they never do. And then, so by law, they're supposed to give you a review within 180 days, but there's a huge political component to it because you have to get them comfortable, meet with them, answer their questions, and it's the back and forth. And the application's quite long too. There's a lot of parts to it.
And when you get approved, do you think you'll offer sports event contracts in the same vein as?
Of course. I mean, if they're doing it, yeah. If it's legal, yeah, I want to do it.
If they were approved, they had the presence of mind or the foresight to become a DCM in, I think, in 2020. There were always some earlier efforts by DCMs to offer sports contracts. The ErisX application. How come more companies didn't put themselves in a position to at least be ready if anything changed?
Well, I'm one of those companies because it's very expensive and it looked very uncertain. So I don't think Kalshi themselves had any intention to do sports whatsoever. I think they wanted to do just events, and then they thought politics is where it's at. That's where we're going to get the volume. So then they pushed a little bit on that politics door and then bust through that with that federal judge giving a stay. And then they're like, well, shit, if we can do politics, what's next? And so I think they did it sort of by accident. They didn't found the company to blow a hole through this. When Kalshi, Tarek called me when he first started and we talked, and we actually, Smarkets looked at doing a CFTC thing way back. I don't know if you're familiar with like the no action letter. We thought about doing the no action letter, like Iowa prediction markets or like predict it. And then we thought that's too restrictive and it's not that interesting. And then the full blown tilt, which Tarek ended up going down, was just too expensive and too speculative because, and this is very true leaving aside sports is a game changer, but event markets without politics is dead. I mean, there's nothing, not that many people want to trade on the job numbers and like the weather in Florida and things like that. There's not enough daily activity so I also thought it was politically unfeasible, not possible for them to get the permission to do elections. Had I had known that there was a high probability of elections getting approved, it would have been a no-brainer. But I thought it was a sub 5% chance to get politics, and I thought it was a sub 0.1% chance for sports to be approved.
I mean, it's just everything changed when the prediction markets correctly forecast Trump's election, and that's
the wrong way to think about it. I have a pet peeve with that. That's the wrong way to think about it.
Well, what's the right way to think about it?
You want to think about it like a weather report. So if the weather report says there's a 60% chance for it to rain and it rains, you're like, oh, okay. And if there's a 60% chance to rain and it doesn't rain, you don't say, well, the fucking weather report is a piece of shit. I'm never going to use it. It's basically the best guess of the probability distribution. And if you have 10 days and there's a 60% chance to win, it's not going to rain 4 out of those 10 days. So the way people think about prediction markets being quote unquote right or wrong is the wrong way to think about it. It's got a price that implies the probability of what's going to happen, and things that have a 70% chance don't happen 30% of the time. So I would not characterize Kalshi got the election right. I would say the 70% chance was a good number. And, we can't do the counterfactuals. We can't run the election 10 times to see if Trump wins 7 out of 10, or if he would have won 9 out of 10 or 2 out of 10. I think that was particularly interesting during the Hillary one, where Trump had a 20% chance to win that election. And everybody said at that time, the prediction markets were wrong because Trump won and said 20%. But no, every time you have 5 elections, Trump's going to win one of those. That's the right way to think about it, like probability. But unfortunately, humans, it's not very intuitive probability with people.
Thanks for that explanation. But I would say he began to look kindly on that whole vertical because it fed his ego. This public or crowdsourcing over all this, or the trading, was in line with the correct, result. And I think that sort of opened his eyes, fed his ego. And
the thing that surprised me, though, is that I thought Trump, with his corruption, like his casino buddies, like the Adelsons and whatever, would call him and be like, don't do this. And, I thought, whether it's like Bloom in Illinois or Adelson or, these like casino magnates, I thought they would put a stop to this. But corruption went the other way this time.
Well, nothing. On the one hand, your buddies telling you not to do something. And then on the other hand, you install your son in the company.
Well, it's because Don is a prediction market expert. Everybody knows this. I've
gone to gambling conferences for so many years, and he's always front and center, rendering strategic advice.
He's always emailing me for how does this work and learning the industry inside and out. So, but besides the law, do you want to see this? Do you want the CFTC? Like, let's say Congress cleaned up the act and everything. Do you want the CFTC to facilitate sport trading, or do you want it to stay in the States?
I think you could they could coexist. But having permissionless, autonomy, which is really what Kalshi is doing. They don't even have to ask for permission anymore. They self-certify. And eventually they're going to self-certify themselves right up to the line where their product is almost indistinguishable from the state sports betting regime.
From an innovation point of view, don't you want companies push? I sound like a crazy like Silicon Valley guy, but most companies operate in a self-certificate. Think about every private enterprise out there. They don't have to certify everything that they do when they ship a new product. Like, why should financial products be so restricted?
It's not a financial product. It's a sports wager, and we have a history in the United States of and around the world of sports-related corruption, match fixing, insider information, point shaving. This is not just a financial product. This undergirds the entire integrity of sports, and it's to be treated a little bit differently. And there need to be some guardrails in place and consumer protections and sort of RG related stuff as well they're not the same thing as some of the other financial products traded on these exchanges. And I think we need to not recast or relabel sports wagering as a financial instrument that is between traders.
This is where I disagree with you. I do think it's a financial product. Just, like there's no responsible gambling in stock trading.
Who's buying and selling the contracts? Just market makers and financial firms? No, they're consumers.
That's the same in the financial industry too. They're just bettors with a bigger bankroll, but it's the same mechanism.
Where do you think the $15 million of Kalshi's revenues are coming from? Probably mostly from the retail side of things and from consumers who are participating in both the DraftKings, FanDuel, and other state licensed sports books that are now trying out Kalshi.
What does that have to do with the fact that they're trading what I would call a financial instrument? Who cares if they're retail or not?
What safeguards are there in place to exclude or limit problem gamblers?
As far as I know, there's no safeguards. Anybody can sign up for a Charles Schwab account and trade stocks, and they don't check if you have a stock trading.
They do in sports betting. They do under state licensed sports betting regimes. You're comparing financial instrument to financial instrument. Sports raises a whole different set of concerns.
I disagree with that.
Okay, you might disagree with that, but do you think the existing regulatory framework on the CFTC is enough?
I think it's way better than the states.
No, not at all. The only advantage from CFTC regulation is uniform regulatory approach that applies across the board as opposed to 50 different state regulatory silos. But the cooperation, the information sharing, the protections that are in place are much more consumer oriented and go further to safeguard sport integrity than the CFTC regulatory framework does, which is really non-existent. And the NBA and Major League Baseball have both submitted comment letters to the CFTC complaining about or decrying the paucity and absence of any sports-related integrity protections. For example, Major League Baseball can't even get any answers from any of the brokers or exchanges.
You've hit one of my hot button issues here. The biggest integrity issue in sports betting is that people who engage in sports betting are getting absolutely fucking ripped off every time they place the sports bet. Like all this sort of safer gambling and like integrity about cheating in sports, people pay an average margin of 10% per sports bet. Like there is no consumer protection in sports betting. Like people are literally getting their face ripped off when they place a wager in sports.
I raise one thing, sports integrity, and you shift it to the holds and to the profit margin. Let's stick with sports integrity. You can't have a framework that works.
Are you talking about people fixing matches? Is that what you're talking about?
I'm talking about monitoring for suspicious or unusual wagers. I mean, listen, as more and more sports are wagered upon every day, all these leagues, tens of thousands of people who are part of the economy around professional and collegiate sports, you have to have some type of regulatory framework in place to ensure that people aren't gaming the system, acting on inside information, fixing matches. What does the CFTC have to ensure against that? They have, their protections are on price manipulation, not sports-related integrity. And none of that even exists.
So there's no insider trading rules and things like that on the CFTC that can apply to this?
There's no framework in place. You could have rules, but if you don't have staff that's dedicated.
I think one of the, operating principles of the CFTC. Now, it might not be being enforced, but
core principle number 2 or whatever, core principle number 3, anybody can write a rule, but you have to execute on the rule. And the states, the gaming commissions, the leagues, the regulators, the sports books, they have a statutorily mandated process in place.
Yeah, but we all know it's not that great.
You may think it's not great, but it exists. It's enforced. It has guardrails. Now, can those guardrails exhibit vulnerabilities from time to time? Of course. And until you have complete national, you could have if you have like one clearinghouse where everything could be evaluated in one place, you may have a more efficient way of monitoring sporting event integrity in real time. But at least the states are doing a lot. There haven't been any significant integrity scandals. There have been from time to time, you had some isolated issues, the Jonte Porter scandal, but that was flagged in real time by an integrity monitor. They caught that. Is the CFTC positioned to do the same, perform the same role? And I submit that they're not right now.
Sports betting regulation in the U.S. is kabuki theater. They're doing it so that the leagues can protect their brand image and all this kind of stuff. And the whole thing is designed so that the leagues pilfer all the money from these bettors who are getting their face ripped off every time they place a bet. This is not a good status quo.
No, but you're talking about we're two ships passing in the night on the ship. I'm focusing right now on the sports integrity.
I'm talking about lowercase I integrity.
I agree. I would love for there to be a way to have exchange wagering.
And you need Kalshi for that. I mean,
you don't need Kalshi for that. You need to amend the Wire Act to approve state to state.
But nobody's going to do that.
It doesn't mean it can't happen. It just the Wire Act is this antiquated law that has created some barriers and obstacles for sports books and states.
And it was designed as a tool to go after the mafia, which they don't really need that tool anymore.
But come on, you're down to like one commissioner, two commissioners. You don't have any staff with expertise on sports. You don't have any gaming expertise in the CFTC, and Kalshi is operating in a permissionless environment where they're almost self-regulating, and they're adhering or claim that they're adhering to these core principles, but there is no watchdog to ensure that the public is protected or that the underlying sporting event integrity is protected. You need to have that. I'm not saying the CFTC is completely incapable for time immemorial of handling that, but right now it doesn't have that expertise. It does not have those guardrails in place, and it is acting, or Kalshi, in my view, is acting without any kind of congressional authorization. So while I favor the existence of prediction markets generally, and I think that this is a great product, an innovative product that can really excite the consumer and create a new product to exist side by side with traditional sports betting products, I think the regulatory framework that exists on the state level is largely absent on the federal level. And I'm not saying it can't exist in the future, but right now it's not on par with state regulation from both a consumer protection standpoint and a sports integrity standpoint. And you can't convince me otherwise. I mean, just because the core principles are declared by Kalshi or there are rules that are in place, the staff isn't in place. The expertise isn't there. And even the DC Circuit recognized in granting or denying the CFTC's motion for stay in the election case, the DC Circuit expressly stated that the CFTC does not have the expertise to protect the integrity around election contracts. That's a quote right out of a DC Circuit opinion that is a published opinion. So we could debate it, but a three-panel judges, one level below this U.S. Supreme Court, seems to agree with my basic premise.
Well, to summarize, legally speaking, I think I agree with most of your arguments that the CFTC or whatever, Kalshi's over their skis from a federal regulation perspective. My guess is that the federal courts will still give wide berth to the federal government to handle its affairs the way it wants to. So I think Kalshi will be victorious, even though intellectually, I think you have very strong legal arguments. In terms of your argument about states doing a better job than CFTC, I'm very against that. I really don't like the way sports betting is regulated on a state level in the United States. I think it's kabuki theater, and I think consumers are getting ripped off. And I know you're saying I'm pivoting it from big I to low I, but I think ultimately it's not run very well. And we need innovation in this space. And that's where I'm like all for Kalshi, just trying to, it's a little bit the Uber playbook of, ask for forgiveness rather than permission. I'm sure that they're rounding some corners some places, but I'm enthusiastic.
Yes, I'm enthusiastic about the legal controversies for sure. I mean, it's one of the most exciting areas for me to wade into, but there's a world of difference between Uber and Kalshi. Uber does not operate in a gaming or heavily regulated, other than taxi and limousine commission regulation space. We're talking about gambling, and we're talking about an agency that has rules expressly prohibiting those kinds of contracts. We have a federal statute that expressly prohibits this activity. So I wouldn't put Kalshi on par with Uber. Yes, it's disruptive. but it's operating in a
Yeah.
different
And I would counter that
regulatory
by
and
saying
legal
I think a
environment.
sports words is a financial contract and should be treated like a financial contract. And I think this idea of calling something gambling is an emotional concept and not a legal concept.
It is a legal concept. The definition of bet wager is you staking or risking something of value on the outcome of a sporting event or a contest for which you're going to win a prize. That's not stock market investing.
That's not a legal definition.
It is a legal definition. Under the unlawful gambling, under UEGA and under most state statutes, bets or wagers are defined.
UGA got repealed, right?
No, it didn't get repealed. And UEGA didn't use the word sporting event, but it was staking or risking something of value, check, on the outcome of a future contingent event, which you can check, and for which, a prize is awarded. So it's three elements of gambling. And future contingent event could be interest rates, could be anything that you place a wager on. But I think it's not even a matter of debate that Kalshi has held itself out as offering betting and wagering. Its own advertising says that. The definition of bet or wager fits neatly into what Kalshi is doing. Can it also be a financial instrument? I suppose. But you can't implicitly repeal the Wire Act simply by labeling something as something different. And certainly, an agency cannot take action that's in violation of a federal statute. If Congress wants to declare these financial instruments as not bets or wagers, that's within the purview of Congress to do, absolutely. But a mere agency, which is not one of the three branches of government, it's a subservient department of one of the branches of the executive branch of the U.S. government, that agency is not empowered to implicitly repeal a federal statute. That's for Congress to do, not for a mere federal agency acting what I think is with a very threadbare, if non-existent, congressional authorization. We can agree to disagree. That's why we have podcasts. And I'm certainly on this issue, I'll admit my view kind of runs, sort of against the grain of what a lot of people want, how the courts are ruling, but I stand by my legal analysis, and it's a long game. Winners aren't declared in the first or second inning. It's a 9-inning game. We have many more courts to go, and I think the issues will be properly framed as we get to the courts of appeal.
Before I let you go, what do you want to be when you grow up?
I'm doing it. I have my own business for the first time. I got married a few years. Everything happened after the age of 55. So if you ask me what I wanted to be when I was 55, I'd probably say anything but what I'm doing then. Now, because of PASPA being overturned, and it's opened up business and a livelihood for myself where I have complete autonomy, I can pick and choose who to work with. There's always people knocking on the door. I'm raising a beautiful young boy. My son, Stepan, my wife, Natalia, and I have been married for 6 years. So I'm doing exactly what I wanted to do, what I envisioned for myself at the beginning of my career. And it's in sports, and it's in something I love to do as well. Marriage, fatherhood, that's number one and number two. But I absolutely get a kick out of what I'm doing. And I'm not just talking about the media, the podcast. I mean, all the attention is nice, and I don't shy away from any kind of interviews or being on a stage. No one ever asked me to speak before I was age 55. Other than doing a couple of appellate oral arguments, I had never, ever been in a public speaking forum before. And now after age 55, all of it has exploded. So I wouldn't change a thing. All I would ask for is, continued good health. That's not promised to you. And continued good health for my family, for my son, my dog. I'm doing exactly what I want to do right now. And life is really good. I'm happy. But most importantly, I wake up every morning excited about what the day is going to bring, and it doesn't feel like work. And that's really, really just reward after 25 years in the practice of law, where it did feel like work every day. And I wondered how much longer I could do it. So I was basically saved by the bell, saved by PASPA. And now I get to enjoy this next stage of my life, which hopefully will be I think it's the most pivotal part of my professional life. And hopefully it keeps going as it's going now and keeps getting better. So no complaints here. So this is what I want to do.
All right. Well, thanks very much for stopping by the podcast, Dan, and getting in the weeds and debating me on the merits a little bit. So
Well, I don't know if there are winners or losers. Judges decide those questions, but it was a fun, spirited conversation. I always like to be challenged. I don't feel like I have to win. And I don't think I did win on some of these points, but it's always fun to be in a mix of a good debate and with smart people who are really experts in their field and from whom I can learn a lot. And the learning here, the learning never stops. And that's one thing I've always recognized. I don't know everything, and I'm constantly questioning what I know and don't know. And I'm always in a quest to learn more, even in this space. I feel as if I'm going to school every day, certainly every week. And that's what makes me better at what.
Awesome. Well, thanks very much.
The Business of Betting podcast is presented by Optimove, the #1 CRM marketing solution for the iGaming industry. 4 out of the top 5 U.S. operators personalize player experiences with Optimove, the #1 CRM marketing solution for the iGaming industry. Learn more about Optimove by requesting a demo at optimove.com/businessofbetting. And if you like what you see, you will get your first month free.